ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, those who are listening, the most honorable President Prime Minister Modi ji, honorable doctors and directors, respected fathers, mothers, ministers, managers, honorable advocates, advertisers, administrators and advisors, dear friends, I Dr. Rakesh from USA heartily cordially welcome. It is really nice time, nice place, nice section. We are discussing today our Indian Constitution. Baba Sahib Dr. Bhimrao Ambedkar, creator, generator, founder, starter, beginner, and we can say maker of our institution, maker, architecturist, designer of our Indian mind, Indian holy motherland, which is based upon its spiritual values, natural values that Baba Sahib kept it in front of the people of the worldly varieties. Unity in diversity is the greatest feature of our nation. Everyone throughout the world accept it. Indian holy motherland is the exclusive holy motherland with its spiritual, meditative, natural values. It has its unique place geographically, socially, politically, economically. Our scholars, students, collegiates, those who are studying, busy in doing research in the different colleges, universities, they read this thing. The history, literature of our country is the most appreciable, admirable, and praiseworthy. All the starters, beginners, creators, generators of the different spiritual missions India's futures. They born in India, came in India to provide the message of oneness, equality, and unity without any discrimination. So great man says there should not be any discrimination on the basis of caste, color, creed, and language, because the aims, objectives, ambitions of our cultural values, national values, climatic values are very clear. This oneness, equality, and unity take us towards humanity. If we have humanity, then we share our sorrows and joys with others. If we have humanity, then we will share. We would like to share our food, clothing, shelter with others. So, dear friends, humanity has a great concept. It is the widest concept in the world. On this basis, if we spend our life, then great men, freedom fighters, free thinkers say that we can be prosperous, peaceful, with having tranquility of heart and mind. These are basic fundamentals for leading the happier life. Now let us discuss Moot, court, exercise, and internship. What is an advocate? First of all, let us know what is an advocate, what are the qualities of a successful advocate. Let us introduce firstly, an advocate is a professional in the field of law and is a person who is professionally qualified to plead the cause of another in court of law. Advocates are trained in the skills of professional advocacy. Advocacy is that skill which is entirely different from other skills, as our learners are being made trained in listening, speaking, reading, writing, words, thoughts, and ideas. So likely that advocacy is entirely unique, different skill of providing justice. Advocacy is said to be a skill. When an advocate or legal advisor puts forward a particular argument in front in a court with a view to persuade the court to come to a decision favorable to their respective clients is said to be advocacy. Advocacy encompasses a range of various skills which are invaluable and important to lawyers. The advocacy can be done both in written and oral form. Advocates need to inculcate a range of abilities. Advocates need to inculcate a range of abilities including drafting, case analysis, using skeleton arguments, advocacy need to inculcate a range of abilities including drafting, case analysis, using skeleton arguments, making all submissions, cross-examining witnesses, and the ability to put forward a strong case. Advocacy is said to be an art. It is best done when an advocate stays true and loyal to their personality. The skills related to advocacy are not only confined to the courtroom but even apply to other forms, dispute resolution, such as arbitration, arbitration and mediation, and also the work lawyers generally do with their clients. According to Advocates Act 1961, under section 21A, advocate means an advocate entered in any role under the provisions of this act. What are the qualities of a good advocate? There are important, indispensable qualities for becoming a successful lawyer? One is good voice. A good voice is one of the most important component of an advocate's identity. Good voice makes it better to understand the concepts. Having an effective voice is essential for the legal profession. An advocate must be flawless and magnificent while speaking. An advocate should know to speak his mind and to get his point across. So this is the first good quality of a successful advocate. Advocate must be fluent in speaking, reading, writing, and listening by his voice. His vision should be higher than a common man. Next quality of a successful advocate: command of words. An advocate should have good command over language. He should know how to speak properly, clearly, and without fumbling. An advocate should possess good knowledge of grammar. Command of words means to have or be in control of the language or to have good knowledge. Basically, an advocate should have mastery of good command over language. Confidence. Confidence is the feeling that one is sure about his own abilities and opinions. Confidence is an important aspect of the solicitor-client relationship. Without a lawyer being confident, a client may be unwilling to accept his advice, and it would be of a bad impression in the court of law. Argumentative. Much of your role as a lawyer involves making an argument on behalf of your client rather than giving into what the other side of the courtroom is saying. You need to be the kind of person who is willing to argue for what you believe in. You need to think of arguments that are going to be favorable for your client and ways to present them in a persuasive way. Intelligent. Becoming a lawyer requires an advanced understanding of the law. Most law programs require 3 years of intense studying and comprehension of legal terms and processes. You need to take the knowledge you learn through law school and experience and apply it to every task you do. Your intelligence can help you ensure you are giving good legal advice and making smart arguments. Persuasive. Much of this role involves persuading a jury to believe your client's side of the case, even if your client doesn't claim innocence. Your persuasive skills can help you get them a better plea bargain. The way you present evidence can drastically alter the way a case concludes. If you are a strong negotiator, you can help your client leave the courtroom in a favorable position. Honesty. Honesty means straightforwardness. Honesty is the combination of uprightness and fairness. It shows the qualities of truthfulness, sincerity, and frankness of a good advocate. The best advocates have always been devotees of honesty. The nobleness of a legal profession lies in honesty. It is very essential for an advocate to be truthful and honest towards his profession, clients, court, and society as well. Determination. Determination is the ability to continue to get up no matter how many times you have been knocked down. An advocate should have willpower, flexibility, strength of character, determination, and a desire to succeed at all costs. Determination is an important trait for an advocate to develop because it is intimately interlinked with one's own personal development and self-improvement. Persistence helps to keep up the work. Determination makes it much easier to face the challenges and improves work. Apart from all these qualities, the other important qualities for an advocate to inculcate in himself are creativity, eloquence, courage, patience, good memory, tact, moral behavior, good conduct, etc. In conclusion, we can say legal profession is a very noble profession. An advocate requires various skills to become successful in his profession. He requires many different qualities and an open-minded thinking ability to flourish in his practicing years. Even though advocacy is considered as a tough profession, but without possessing the above these qualities, a lawyer cannot be a successful lawyer. What are the professional ethics of an advocate? The practice of law is a noble profession. Therefore, observing one's conduct and behavior to a certain set of professional norms is an important aspect of this profession. Legal ethics can be simply defined as a code of conduct which may be written or unwritten. Such a code of conduct is meant to regulate the behavior of a practicing legal professional towards the court, presiding judge, his client, and his opponent in the courtrooms. The primary object of ethics in advocacy is to maintain the dignity and integrity of the legal profession. Legal ethics ensure that the legal fraternity serves the society honestly and present each case in the most formal way possible, so that the litigants have faith on not only their legal representative or lawyer, but also on the justice system. Not only the lawyer, but also the judge needs to have a sense and understanding of legal ethics in order to maintain the functionality of Indian courts. One of the fundamental aims of legal ethics is to seek a spirit of friendly cooperation amongst the bar, bench, and the clients. Standards of ethics exist between the lawyer and his client opponent, and the witness being questioned, and of course between the judge and the lawyer. The legal profession has been created by the state to serve the litigatory needs of the public. Thus, it is not a business, it's a profession. Consequently, there is three fundamental basis of legal ethics that gives an insight into the essence of the legal profession, the organization of its members in order for the performance of their function, maintain certain standards at both the intellectual and ethical level to preserve the dignity of the profession. Pecuniary gains must be subordinate to the client's interest. Bar Council of India rules is framed by the BCI under Part 6 of Chapter 2. This chapter deals with the standard of professional ethics and conduct of lawyers. It is important to go through the rules briefly to understand the importance of professional ethics of a lawyer towards the court and the client. Rules and advocates' duty towards court. The Bar Council of India prescribes certain duties that an advocate must fulfill. One is act in a dignified manner. Any advocate before the court while presenting his case is required to have self-respect and conduct himself with dignity. In a DC Saxena year 1966, this rule actually empowers an advocate to submit a complaint against a judicial officer. However, such a complaint shall be submitted to the proper authority. An advocate must maintain a respectful attitude while at a court and shall respect the dignity of the court. In the case of UP Sales Tax Service Association versus Taxation Bar Association 1995, it was stated that the survival of a free community is endangered if an advocate doesn't show respect or recognizes the dignity of the judicial officer. It potentially lowers the spirit of the court. Not to communicate in private. This rule was well explained in the case of Rizwan UI Hussain versus State of UP 1953. It was observed that an advocate shall not try to seek court. An advocate shall not try to seek favorable decisions by any illegal means, including bribing the court or communicating any favor in private. Thus, this rule prohibits any private communication with a judge which would be specifically regarding a pending case. It is considered as a gross form of professional misconduct. If at all an advocate tries to influence this decision of the court by having private communication with the judge, refuse to act in an illegal manner towards the opposition. An advocate is also required to prevent his client from resorting to unfair practices relating to the court. Opposing counsel or opposite parties or even co-parties, the advocate must honestly restrain and explain the implications and the consequences of such unfair practices. This rule also empowers an advocate to refuse to to represent a client if he or she insists on such improper conduct. An advocate shall have his own sense of judgment and must not use strong language in the court of law. This is another important rule laid down that the advocate is expected to have his own sense of judgment regarding his cause or the case he or she is representing in the case of MY Shared and others versus Honorable Judges of Nagpur High Court and Organizations 1954. It was observed that an advocate is not a mere mouthpiece of the client. Legal counsel must exercise his or her own judgment. An advocate must also restrain oneself from the use of scurrilous remarks while in pleadings. They shall use imperative language during pleadings in court. Appear in proper dress code. Legal profession is one of the few professions that have a designated uniform. The court demands that an advocate must necessarily show up in inappropriate dress code, must show up in appropriate dress code. There have been instances in court where cases have either been postponed or dismissed for that matter due to the lack of proper dress code that should have been followed by the representing legal counsel. Thus, if an advocate is improperly or inadequately dressed, he is not only looked down upon but also his appearance is a breach of the prescribed dress code. Refuse to appear in front of revelations. Refuse to appear in front of relations. This rule is if there is a family tie existing between the presiding judicial officer and an advocate, then the advocate shall not appear in such cases and shall request for the change in bench, not to represent establishments of which he is a member. The rule simply provides that an advocate is not allowed to represent, defend, or even stand against an organization, institution, society, corporation, etc. But he is a part of the executive. He is a part of the executive committee of such institutions. Not to wear hands or gowns in public places. Not to wear bands or gowns in public places. The advocate cannot utilize his or her gown or band in other public places unless in any ceremonial occasions that the Bar Council of India and the court may prescribe. Rules and advocates' duty towards client. Just as an advocate owes duty towards the court, he or she is also obligated to follow Rule 11 to Rule 33 that prescribes an advocate's duties towards his client. They are bound to accept briefs. Rule 11 lays down that an advocate is bound to accept any brief in the court, that is, if he proposes to take up without any fee at the Bar Council. In S. J. Chaudhary versus State 1984, The Supreme Court held that if an advocate doesn't attend a case day to day, he would be liable for breach of professional duty. This observation was based on the fact that a lot of advocates don't appear at the court and then his client has to bear the brunt of it. Not to withdraw from service. Rule 12 provides that an advocate shall give the client reasonable and sufficient notice before withdrawing from an engagement. He shall not withdraw without any reasonable grounds. If he withdraws himself with sufficient cause, he is bound to refund the fee, even a part of it if not earned. Not to appear in matters where he himself is a witness. Rule 13 provides this rule as it can give rise to a conflict of interest. It must be noted that if an advocate is a witness of a party and is asked to represent the other side, then only such an advocate shall refrain from taking up such matters. In Kokanda and Kundaka versus KD Ganpati 1995, the court had upheld this rule as the parties could be disadvantaged. Full and frank disclosure to the client. Rule 14 provides that an advocate is expected to be honest with his client before the commencement of his engagement. He is obligated to reveal whether he has any connection with the other side or parties and any interest in their case. Otherwise, this creates controversies and also affects his client's judgment to carry forward such an engagement or for the interest of the client. Rule 15 provides that an advocate owes his loyalty to his client and must uphold the interest of his client fearlessly and honestly by all fair means. He shall not give regard to unpleasant consequences that he may bear. Not to support material or evidence. Suppressing material evidence is absolutely disregarded in the court of law. This rule is provided under Rule 16. It basically provides that if a prosecutor in a criminal trial tries to suppress material evidence that may lead to the innocence of the accused or taint of the justice of the victim, if shall be considered a gross breach of professional conduct and can also invite legal trouble for themselves. Thus, such an act or omission shall be scrupulously avoided, not to disclose the communications between the client and himself. Rule 17 is also one of the most important obligations followed by an advocate. A non-disclosure agreement is always signed between the client and the advocate. Since they exist a fiduciary relationship between the client and the advocate, breach of breach of confidentiality is taken seriously even at the court of law. This rule is also incorporated in section 126 of the Indian Evidence Act 1872. No charge depending on the success of matters. Rule 20 provides that an advocate shall not charge depending upon the success of the lawsuit. Such a practice is opposed to public policy, and such contract for a contingent nature of fee against Section 23 of the Indian Contract Act. As advocate, an advocate must not lend money to his client. Rule 32 provides that when an advocate lends money to his client, then interest is created. Such a creation of interest, if not allowed, as it affects the advocate's sense of judgment and also disallows the client to think upon before commencing with engagement. Not appear for opposite parties. Rule 33 provides that an advocate shall not represent the opposite party after withdrawing from the case on behalf of the previous party. What is the role of bar and bench in the administration of justice? For the administration of justice, the judicial system is composed of the judges and the advocates who assist the judiciary in dispensing justice through discharging their duties. The bar and the bench are two elements of the same system, and without them, justice cannot be efficiently administered in the courts. Bar, it is an association of lawyers established with the meaning to promote professional ability, enforcement of standards to ethical conduct, the encouragement of the spirit of public service among the members who practice the legal profession. In India, Bar Council was established as a statutory body under the Advocates Act 1961, aiming to regulate legal education and the legal profession. Its members are the lawyers from India and describe the qualifications, duties, etiquettes, discipline, and conduct of lawyers. A place, bench, a place where justice is administered by either judge or judges of the court. Bench could be in court or tribunal. The bench where the judge sits should showcase the position's respect and dignity. Role of bar bench in the administration of justice. Role of bar bench in the administration of justice. The practice of law and the administration of justice is vitally important to each other. There is no other office in the state that possesses the same level of authority as that of the judge. Judges carry enormous powers, far exceeding that of any other officials in the government or military. The common people's lives and liberty, individual domestic happiness, prosperity, and public image are subordinate to the judges. Wisdom and citizens are held accountable for their judgments. if judicial power is corrupted, there is no longer any assurance of life. Liberty is forfeited, and there is no longer any guarantee of personal or domestic happiness. A strong judiciary that is active, unbiased, and competent is the most important thing a state can have. Judges must carry out their responsibilities due to the importance of judges in the maintenance of civil and orderly society. The order, the roles of attorneys and judges are supplementary to one another. The primary source of judges' recruitment is the legal profession. As a result, they are both members of the same community. The bar and bench need to sustain cordial relations with one another. However, because of the nature of the responsibilities that attorneys and judges must fulfill, that may engage in dialogues that are sometimes amusing, sometimes heated, and sometimes tough. What are the duties of bar? To preserve respect for the court, not just for the temporary judicial office holder, but also for the court's paramount significance. Judges, unable to defend themselves, are entitled to the bar's protection against unfair criticism and uproar. The lawyer has the right and obligation to file a severe complaint against a judicial official with the relevant authorities. Such allegations should be increased, and the individual making them should be proceed. Relationships with judges. A lawyer should never provide a judge under attention or hospitality that is uncalled for by the parties' personal connections. He should avoid doing anything to seek or appear to obtain a judge's particular personal regard or favor. Conduct towards judges during trial. To maintain respect and confidence in the judicial office. The lawyer should always conduct himself in polite and courteous manner towards the judge. The lawyer has the right to thoroughly and, and correctly convey his client's case. He should actively submit all relevant reasons against any erroneous decisions and ensure that the case record is comprehensive and correct. Next, number 3 is dignity. Dignity and respect should be maintained by the advocate towards the judge while presenting his case in the court. Presentable manner. An advocate shall always appear in court in a presentable manner and a prescribed dress. In public places, he should not wear a gown or bands. Interruption. An advocate shall not interrupt in between when an opposite counsel or judge is speaking. Monetary interest. If an advocate has a monetary interest in any case, he shall not plead in such a case. No personal influence. An advocate shall not apply any personal influence over the decision of the court, nor he should give any kind of impression that he possesses personal influence with the judges before whom he practices. Well known. It is an advocate knows. It is an advocate knows a judge personally. He should not practice before him. False facts. An advocate shall not present any fact in front of the court which he knows to be false. Duties of the bench. In this state, there is no office of such powers as that of the judge, as the powers which are held by judges are greater than any other functionary. The citizen's life, liberty, personal domestic happiness, reputation, and property all are subject to the wisdom of the judges, and all the citizens have to comply with the judge's decision. If judges become corrupt, there will be no security left with citizens to life and liberty. And also there will be no guarantee of personal domestic happiness to them. Thus the state needs a judiciary that is strong, powerful and impartial. The judges shall perform these duties. One is impartiality. Judges shall act impartial and shall not do anything in favor of his friend and relatives. He must do everything for justice. Two is avoidance of interruptions. When advocates examine witnesses in a case or argue in case, the judge shall make sure that there are no interruptions, unwanted interruption or bad commands by the judges during the hearing of the case disturbs the advocates, and as a result he may not be able to present his case properly. That he may not be able to present his case properly, but the judges can interfere in these following circumstances. One is to prevent waste of time. Two is to check the relevancy of arguments, but to check the relevancy of arguments put forward by the advocates. Three is to get clarifications on a point that is not clear to him. Four is to express his opinion on a point. Five is to promote speedy disposal of cases. Speedy disposal. Cases that come before the court shall be disposed of as soon as possible. As when justice is delayed, it means justice is denied. Avoiding harsh commands. Avoiding harsh comments. Harsh comments shall be avoided by the judge in the court about the advocate's lack of knowledge in law. Similarly, without any sufficient reason, they cannot ask the advocates to leave the court. Judges should possess a calm temper. Independence. The protection of the independence of the judiciary should be prime duty of the judge. Meeting of judges and advocates. At regular intervals, meetings shall be conducted between the judges and the advocates such that they can put forward their difficulties in front of each other and it can be sorted out. This will help in strengthening the bar and bench relation. Integrity. The character and the conduct of a judge shall be praiseworthy, and he should have personal and intellectual integrity. What are the conflicts between the bar and the bench? How can you remove conflicts between them? Let us discuss next time. Next is drafting, pleading, and conveyance. Explain the meaning and object of the pleadings before the hearing of a case starts before the court. It is necessary that the court should clearly know the court should clearly know what it has to decide. Similarly, it is equally necessary for the parties that they should also know what they are fighting over. To achieve this object, the plaintiff is required to state his case in a document, and such document is known as plaint. When the plaintiff files the plaint in the court, then the court issues summons to the defendant and orders him to appear in the court on the date mentioned therein and submit his answer to the plaint. The defendant is expected to submit the plaint after studying and examining the points